Well, welcome to today's episode. I am so lucky to have Lauren Brown here with me. She's actually one of my favorite attorneys ever. We work really closely together with many families. But my introduction of her, and Lauren, I'll let you add anything you want, is that not she works at a law firm that only hires probate and estate planning attorneys. So having that niche and that focus, that expertise, I think adds a ton of value as we're navigating estate planning. But as a financial planner, I've worked with a lot of attorneys, and you are the only one that includes an asset memo at the end of the document preparation, which tells us as a financial planner, hey, how should these accounts be titled and these beneficiary designations be updated so that this estate plan actually works properly. And so because you do that, you've become my best friend in the estate planning scene. Super happy to have you on this podcast to be able to share some of your expertise. Is there anything you would want to add to your introduction on top of that?
Well, I mean, what I would say is, the asset memo part of that is our firm believes that kind of a team is important in the estate planning process. So making sure that somebody's CPA, their financial advisor, the people that assist them with all these other areas that impact their estate plan, that increases our odds of success in terms of implementing their plan. And so including everybody in the process is really important.
You're tuned in to the Matchpoint podcast, How to Win the Money Game. I'm your host, Thomas Cook, financial planner and founder of Retire to Teleco, a wealth management firm in Knoxville, Tennessee. And together, we'll navigate the financial court of life to help you maximize your wealth and minimize taxes in retirement. Teaser for later on in this episode, you came and did a professional presentation to the Financial Planning Association that was called the reading of the will. So and all these things that happen before the will even matters, contract law and all that. So we're going to do a deep dive into estate planning, but let's just start with the basics. So Lauren, what is estate planning and why is it important?
So estate planning provides a means by which you can provide for both how assets pass after your death, obviously family, money, how you're leaving money to family, family issues, how are we decreasing tension and the potential for disagreements. But it also involves how are we handling assets on your behalf. If you become disabled during your lifetime, who can make medical decisions for you? Who's going to make sure your bills get paid? And going ahead and having a plan in place so that your family members aren't adrift and trying to figure this out kind of in a moment of crisis.
Yeah, this is one of those topics that's hard to talk about because nobody likes to think about future uncertainty around their health, when they die, their ability to make their own financial and healthcare decisions. But it is so important. And like you said, in a moment of crisis, I've seen families who absolutely love each other in a moment of grief do things that they wouldn't have done otherwise. And I think a well
Right.
laid out estate plan could have avoided a lot of that grief and allowed people to do that, just grieve, and not have the stress and the financial uncertainty of all the other things. So even though it is a hard conversation to have, it is so valuable
And
to
we do try
have
to
it.
make it as painless as possible. We know it's not something
Yeah.
most people enjoy talking about. And for most of our clients, they, at the end of the process, express what a relief it is to have it done and to have certainty themselves as to who would step in and manage things, how things would be handled. But we always tell people, I think one of the biggest hangups, or, they're kind of two, it's not wanting to talk about it. And then the second one is people aren't sure what decisions they want to make. And they feel the need to have kind of all of these answers before they come and meet with us. And we kind of always tell people we have tools in our tool belt that you're not aware of. And so we can normally get you where you need to be at the end of the
Yeah,
day.
actually, I think that's one of my favorite things about working with you as well is your ability to counsel people. So, and the difference of just doing this online, because there are a lot of online providers now where you can get a basic will or power of attorney, and that may be better than not having anything. But I think having the in-person counsel, and for those people who, have these uncertainties and just, they're letting so many decisions paralyze them from taking action. I think that's where I've seen you come in, and you're really gifted, a really good listener, being able to come in, ask the right questions, and I've heard it from my clients. They feel so much better after they have their estate plan done. So it is a huge burden. It's like one last thing that you can do when you leave this world is to make sure that, you've taken care of the people you're leaving behind,
And
how
that's
you
really the
want.
thing. People are dreading the conversation, but a third of our conversation is tell me about your kids. What are
Yeah.
their strengths? What are their weaknesses? Do you like whoever they're dating? Do you like their spouse? Tell me about your grandkids. Are they doing well? Are they healthy? Are they meeting all their milestones? How do they do in school? And people enjoy talking about their kids and grandkids.
Yeah.
So, some portion of the conversation is actually fairly enjoyable for a lot of our clients. And then after gaining all that information about their family, I can kind of help guide them. You've told me that, your son gets really emotional, that if mom were ever sick, he'd have a hard time dealing with that. Maybe he's not who we want to make medical decisions. And so that really does assist us in the process with helping mom and dad know who to appoint to handle certain things, or how to handle kind of a child's inheritance. How can we best protect their children? So a lot of it
Yeah.
really is about family, and the conversation is about your family.
Yeah. Yeah, it is a good conversation. Yeah, it's all about them, their values, their family, their wishes. So let me ask you this. A lot of people move in general, but especially we see this trend here in Tennessee. A lot of people move here for retirement, lower cost of living, no state income tax, property taxes are low. So why is it so important when you move to a new state to update your existing estate plan?
So it's not always necessary to update all of the documents in your estate plan, but when you move states, you should have an attorney in whatever state you're now a resident review your documents. Okay. So, you know, wills, there are different execution requirements in different states. I've seen wills that come here that there are 3 witnesses. Tennessee usually requires that it be witnessed by 2 witnesses. There are older wills where maybe the witnesses have just signed once and there's no kind of what's called an affidavit of subscribing witnesses or self-proving affidavit at the back of it. If you pass away and your will's executed in that manner, we have to hunt down those witnesses. And if your will's 20 or 25 years old, it can be really hard to find those people. So, there are things that it's important that we update and go ahead and correct. In addition, the powers of attorney, what we call an advanced care plan, or sometimes people will have a living will in the state of Tennessee, those documents differ kind of state by state. They're state specific documents. And so it's really best to kind of update those once you become a Tennessee resident, or if you move to a different state, once you become a resident of that state. Because if you're in the hospital, it's best to hand them a document that they're kind of used to seeing. They're used to looking at the advanced care plan. They understand what that covers. Financial institutions are used to seeing the Tennessee power of attorney language. And it's going to make things go much more smoothly for your family members. And those documents are fairly simple and easy to get in place. And so again, it's just really best to update them once you've moved. There is reciprocity. So if you've been here, several months and an emergency happens, they're going to take your older documents. It just may be that your family members have to jump through some additional hoops, or it's a little more difficult.
Yeah.
Okay.
No, that's a great, you are a great educator. That's a great explanation. Yeah, because so Lauren and I are both part of the Knoxville State Planning Council, and we had the county clerk come and talk to us. And he gave that example, of an out-of-state will that didn't have the self-proving affidavit. Well, then you have to go track down those witnesses. So yeah, it is just, would you call it best practice to update your estate planning documents when you do have a new residence because of
Yeah, I mean,
some of those nuances?
once you've moved states, yes, you should have them reviewed again
Yeah.
within the first 6 months to a year after you've moved. Just get in with somebody. And if you've been one of our prior clients, or even, I know you've called our office before asking for kind of an attorney at a different state. We have a way of kind of, if you've moved somewhere fairly close, we can find attorneys we've worked with in the past in other states who specialize in estate planning, kind of like what we do, that aren't kind of a jack of all trades where I'll handle your divorce and your DUI and do a will for you. We really want to make sure that our clients are meeting with somebody who does specialize and focus in this area.
Yeah, no, that makes a huge difference, and yeah, you guys have been a really helpful resource. So let me ask this. So let's say you have your estate planning documents. When does it make sense to review them and update them?
We tell our clients anytime there's a major life change. So if you have a child or a grandchild that there's some sort of illness or something, it looks like they may be disabled long term going forward. If a child is getting a divorce, or a relationship looks rocky all of a sudden, if you win the lottery, reach out to us because all of that may impact your estate plan. And so we may want to update your documents at that point in time. If something happens to one of the individuals you've named, so if you have kind of a key family member that you've appointed in all of your documents, and you have a falling out with them, or they're no longer able to serve for one reason or another, we may want to update things. Sometimes we're the not top of your mind in those situations. So you can have kind of an emergency family situation, you get through it and you're not thinking, I need to call Lauren, that's my next step. And so kind of we tell people as a rule of thumb, every 5 years, pull it out, look at it, see if it still does what you want it to do. Do you still understand it? If the answer to either of those questions is no, call me and I'll walk through it and we'll determine if changes need to be made. That's a good rule for most people. For our clients who have kids between the ages of like 15 and 30, the 5-year rule becomes every 2 to 3 years. And that's just because your kids are going through so many life changes during those years. So suddenly these cute, cuddly little kids that, could never do any wrong, are managing money on their own. They're going to college. You're seeing what decisions they make once they have a little bit of independence. They're graduating, they're getting a job. You're seeing how they're managing their finances now that they're on their own. You're seeing who they're dating and who they're marrying and what those relationships look like. And so parents tend to update their estate planning during those years with greater frequency. And so again, it's just pull them out, look at them. Do they still do what you want them to do? Do they still make sense to you? And if the answer is no, call me, okay? And we'll kind of walk through them and determine if changes need to be made.
Yeah. Yeah, that's a great reminder. And that's funny. That is especially, if you do this, like you said, I have a 3-year-old and a 1-year-old. They're cute, perfect little children. But to your point, yeah, they may have totally different views on managing money or healthcare decisions down the road that I would want to revisit this and make sure, yeah, are we setting them up for success? So, and I worked at the trust company in Tennessee, and we managed a lot of trusts, and it seemed like a lot of the trusts were catered around that, helping children, setting them up for success. So, maybe without getting too much in the weeds, but just where control was more important than flexibility. So if you happen to, and maybe you could speak to this, but some of the situations I saw were maybe like I don't want to say wayward, but maybe somebody that would spend all the money immediately on a short-term need without considering long-term well-being, or maybe somebody that had an addiction. I felt like that's where some of these trusts were created and needed to be updated as kids age. Is there anything you would add to that?
What I would say is, I guess my philosophy is I meet with a lot of clients that still have young kids. And so yours are, you said 1 and 3. Is that, so, it's hard to see where they're going to be. You obviously have hopes and dreams and aspirations for them, and you hope they're going to be amazing people that manage money well and are making great decisions. But it's really hard at 1 and 3 to know how that's going to progress. And so if something happened kind of before you had more information, it's really hard to make decisions as to how to handle it at this age. And so I tend to go with, let's give other people control, particularly depending upon kind of what amount of money we're leaving these kids, but build in flexibility wherein trusted family members have the ability to loosen the reins when they feel like it's appropriate. So if we don't get to the point where your kids are 16, 18, 20, 25, and you can kind of see who they are, let's maybe have a trust where we don't have mandatory payouts at set ages, but let's have family members who have the ability to appoint the child to serve as his or her own trustee at certain points when they feel like the child has gained enough experience and maturity to handle assets wisely. So I think there is kind of this balance of making sure this beneficiary is protected while still building in some flexibility. Obviously, with some clients, when we're dealing with addiction issues, sometimes, yes, the protection element outweighs the flexibility, because we don't want somebody to take this money and go do something kind of harmful for themselves. We want it to be a safety net for them.
Yeah. Wow. Yeah. What you do is so incredibly important. And there's so many different family dynamics and yeah, and maybe that could be a whole different separate podcast, when to have a trust, when not to have a trust as part of your estate planning. But
And I know one of the things
maybe
Lisa
high level,
Gameltoft
what
says
would
in
you?
a lot of her presentations that when she first started practicing, kind of estate tax and the Tennessee inheritance tax was such a big piece of what we did. And that's true of the beginning of my practice as well, because the exemption amounts were $1 million when I first started practicing. And I think it's shifted over the years where a lot of our practice really at this point revolves around blended family planning. There are many more remarriages, children with kind of addiction issues or mental health issues. How are we planning for those kids and making sure they're taken care of when mom and dad aren't here to kind of be in control of things? And I think that's a much larger part of our practice now is addressing those sorts of needs for our clients.
Yeah. Yeah, so talk to us about this. So, yeah, things definitely have changed with the Tax Cut and Jobs Act. Like you said, the exemption is much higher today than it was when you first started practicing. Um, but with probate court, I know sometimes you hear, especially people that follow any online media, they've probably heard avoid probate, avoid probate, avoid probate. Whether it's for like cost or privacy. But I've heard you explain, well, probate in Tennessee is actually not that bad, and there may be some things you want to, some assets you want to flow through probate. So could you talk to us a little bit about probate court and why it may not be as bad as people think, at least here in Tennessee?
Well, when people try to avoid probate, they do so in kind of two different ways. Okay. And what most people do is they'll get some misinformation from friends and family members. I saw like something floating around on Facebook recently that was like, here's how to avoid probate, title all your assets jointly, put your kids' names on all of your, bank accounts and investment accounts, name beneficiaries on everything, advise people to transfer on death deed, which isn't an option in the state of Tennessee, and it's not an option in every state. And that can yield really bad results for people. Okay. What some people don't understand is you throw a child on a joint bank account or you throw them on as an owner on a bank account. They are a joint owner. So they own it, which means it's exposed to their creditors. It's potentially on the table if that child gets divorced. We've also had situations where maybe the child that's local and here that's helping mom or dad gets added, but not other children. And so parent has kind of unintentionally disinherited kids that just didn't get added to the account. And sometimes parents aren't given the information that, you title something jointly with someone, it overrides your will or your estate planning documents or whatever verbal wishes you think you've told your family members. That account is going to pass to the surviving joint owners. In addition, it may exclude grandkids. So even if you get, you have 3 kids, all 3 names are added to the account, you're willing to accept that you've exposed your account to liability for your kids' creditors. If one of those children predeceases you, you may exclude his or her kids because it's just going to pass to the other 2, and they may or may not choose to share with niece or nephew, or there may be legal barriers standing in their way that makes it hard for them to do that. Okay, because there is still a federal gift tax depending upon what state you live in. There may be a state gift tax. And so there can be some really bad results if someone dies out of order or if one of your kids gets sued. Even with kind of the POD, TOD designations, with some of those you can get a little more specific and try to provide for grandkids or for things to pass down. It doesn't create kind of the liability issues. But with some of those designations, it doesn't allow for that. So we may still have the same issue where you've excluded grandkids. Some people, the ones that get better advice, may try to avoid probate using what's called a revocable living trust. And so, with the revocable living trust, if you've either transferred all of your assets to this trust during your lifetime, or you have named the trust or a person as a beneficiary at your death, we don't have probate assets. Okay. And so this court or this trust document doesn't get admitted to the probate court, and you avoid that process. What people don't understand is that's not a magic wand that kind of means all your beneficiaries get all the assets day 2. So what I tell clients a lot is whether we've got a trust administration or a probate administration, your trustee or your personal representative still has an obligation to people other than the beneficiaries. So they have to pay final medical bills and funeral expenses. They got to file your final income tax returns and pay the IRS and the Tennessee Department of Revenue. And so there's still things that need to occur, and that's a process. You're wrapping up someone's final affairs. And wrapping up a person's final affairs doesn't just involve giving a check to all the beneficiaries the day after that person passes away, unfortunately for family members. Probate in Tennessee is fairly cheap, easy, quick. Okay, so in most counties, we can mail in the probate pleadings, they mail letters testamentary back. We can have things opened within a couple of weeks, maybe to a month, depending upon what county we're talking about. Once the estate's open, they publish a notice to creditors in a local paper. And it has to remain open for at least 4 months after that notice is published. And that's just to give your creditors time to come forward and file a claim and ask to be paid. The probate court can actually provide a benefit in certain circumstances. So if we know there are potential creditors out there, we want some finality in terms of who's owed what, the probate process is a really good way to do that. If we actually mail them a copy of that written notice, we know they have to present their claim within 4 months or they have to go away. Okay, and that lets your approach representative know, hey, I can go ahead and distribute things and I'm off the hook. If this person shows up 9 months after mom's death and tries to present a bill, I'm good as long as I've sent them that notice. Anybody that doesn't get the notice has up to a year. So it kind of depends upon how much we know about mom's affairs. But again, it does provide some nice finality.
Yeah, and I would say that that's the reason that I would want to work with an attorney through this process because the average American probably doesn't know that if they send the notice, they have 4 months versus a year, and like that could say that could protect a lot of assets for heirs instead of going to creditors. So, yeah.
Yeah. But once the estate's open, courts around here are pretty hands off. So Knox County in particular will call you down and ask, if the estate's been open a certain period of time, they'll set what's called a hearing to appear and settle. And it's just you going down there and saying, here's why it's not closed. But generally that's if it's been open in excess of a year. Okay. Outside of that, you can go to the court if you need something from them, but they're not necessarily going to be involving themselves in the administration. At the end of it, you do need to kind of account to either the court or the beneficiaries. If we account to the beneficiaries and they all sign receipts saying we're happy with how things have proceeded, the personal representative is going to file certain pleadings to close the estate, and they're done. And so that's kind of the court involvement. It's filing pleadings to open, filing pleadings to close. Again, if we have creditors or, if somebody tries to file a claim that we don't feel like is valid, the court is there as a means to go down there and have them adjudicate that and say, nope, this person doesn't get paid, or you do owe it, but you owe half of what they filed for, or whatever. If a beneficiary takes issue with something that's being done, they can file something with the court and appear and express kind of their grievances. So it can be very helpful in dealing with some of that, actually. But outside of those sorts of things arising, it's filing something to open, filing something to close. So again, they're fairly hands-off. There are a lot of people that move here from out of state that may not be their experience in other states. So I know a lot of people that have moved here from California or Michigan come with revocable trusts because probate is kind of a painful process in those estates where the court is very involved in the process and it can be fairly expensive. And so they put revocable living trust in place to try to avoid it. But in Tennessee, there are a lot of good reasons to have a revocable living trust, but it's not a one-size-fits-all solution.
And what would be some of those reasons that you think would just in Tennessee justify having a revocable living trust?
If you own out-of-state real estate, so for some of our clients, they have their primary residence here in Tennessee, they have, a home in North Carolina or a place in Florida, Hilton Head, something like that. So if you own real estate in multiple states, timeshares can be real estate if they're deeded instead of points. In addition, oil and mineral interest are real estates, and we do have some clients that have those. But a court in Tennessee can't transfer dirt in another state. So we have to probate your will here in Tennessee, and then we have to probate your will in each state that you own real estate. Sometimes a trust can be helpful because we can dump all of that real estate into the trust, and then we just have to get somebody to prepare a deed deeding it out, but we don't actually have to do a probate administration in 2 or 3 or 4 different states. Sometimes we have clients that need a professional fiduciary to step in if they're incapacitated. So a bank or a trust company, they don't have family members that can step in and pay their bills and file income tax returns and handle that on their behalf. And most professional fiduciaries around here prefer to serve as trustee. And so for those clients, we really need a revocable trust in place. We also find it helpful for clients who have privacy needs. So if we have kids with addiction issues or mental health issues, and we're including very specific language in our trust, once your will is admitted to the probate court, it is a public document. And so people can call and request a copy of it. They don't have to show that they're interested in your estate in any way in terms of being a beneficiary, and the court will send them a copy. A revocable living trust, because it's not probated, it's never filed with the court. And so the only people entitled to a copy at your death are the trustees and the beneficiaries. And so if we've got very sensitive information about the beneficiaries in there, we can keep that private by using a trust.
Yeah, that's such a great summary. Thank you. You are clearly an expert, and it is so gracious of you to share all of this with us. I am curious, what is your thought where like privacy is important? How hard is it to access public records if you don't go that route? So if it is prorated, like it's still not that it's not like an online Google search. My understanding, correct me if I'm wrong, like they still have to go down to the courthouse and like get permission to go look at the record. Is that how that works? Is that
I mean, I feel like with most of the courthouses around here, you can just call. So I've called before and said, "Can you fax me this will?" And I was an attorney of record. I didn't necessarily call in my
huh.
you know, capacity as an attorney. It was just this family members maybe inherited something from this person. Their spouse asked me to request a copy, and I called down and asked, and the court sent it. So it's fairly easy to get your hands on a copy of somebody's will once it's been probated. Okay.
Yeah, that's interesting. Thank you. So, um, yeah, great summary of
But
what,
most
privacy.
people, have you ever called and requested a copy of someone's will? I mean, it's not that interesting as a general rule. Most wills say what you would expect them to say, and it's kind of, here are my family members, here's who's in charge. And then, if you have kids, here's how things are divided, typically equally between them. So as a general rule, there's not a whole lot in there that you're necessarily overly concerned about people seeing, because it's kind of
Yeah.
as you would expect it to be. So it's people that kind of have very specific language in their documents that they want to keep private. Sometimes if we're disinheriting one of our children or grandkids, having a trust administration over a probate administration can make it a little harder for that beneficiary to contest what you've done. Okay, so it's fairly easy for even your average layperson to go down and file something in probate that may not be successful. But if a beneficiary files something, there's going to be a hearing set, and the attorney for the estate has to appear, and it's going to cost the estate money. A trust can cut down on some of that if we have a family member that we feel like might just try to harass the estate or not necessarily love what we've done.
Okay, that's helpful. So high level summary, just to put a bow on this part of the conversation, the reasons to or why probate isn't that bad. What you said, finality, with creditors. What would be the other bullet points, high level?
Um, I mean, just for your average layperson, I do think finality with creditors, it's a very similar process either way. So whether we have a trust administration or probate administration, your family members are going to be doing very similar work after your death. It doesn't change a whole lot there, kind of on their side of things. Proceeding with a trust, a revocable living trust, does put more of a burden on the client because they have to make sure that assets are transferred to the trust, and we do assist with that, or that they've named the trust as a beneficiary. And then they have to keep that in place through time. And when they're working with an advisor, the odds that they do so are pretty high as long as things are fairly well consolidated and their advisor knows about kind of outside accounts and what's been done there. For our clients that maybe aren't working with advisors, the odds of success there aren't as high, okay? Because inevitably they've got some sort of bank account that is still in their name. They haven't made it payable on death to the trust. And so we still have a probate administration at the end of the day anyway. So if that asset isn't already titled to trust or it doesn't name the trust as a beneficiary, we have to proceed with some sort of probate at their death to get it into the trust. Okay. So, again, you're taking on more of a burden moving forward, kind of if we have a trust, and you've got to make sure that there's a reason for doing that.
Yeah, that's really helpful. Thank you.
There has to be a
Um,
benefit in order for them to kind of agree to want to proceed with that. Now, I do have some
yeah,
clients that still just want a trust because they had a parent that had a trust, and
yeah,
their only reason for doing it is to avoid probate, and we'll still gladly prepare a revocable living trust for you if that's your reason.
yeah. Yeah, and we don't have to spend a ton of time here, but I am curious on irrevocable trusts, I know sometimes these are set up maybe for a high income earner that may have be more subject to creditors, like let's say a medical professional. So maybe for that asset protection. When do you think it makes sense to have something in an irrevocable trust while you're living? And then the second part of that question would be like, and how hard is it to, if plans change and you actually needed that money, how hard is it to now, since it's an irrevocable trust, like to actually get that, be able to, I don't know. So that, I guess, can you speak a little bit to that? Just start with irrevocable trust. When would that ever make sense while living to set one of those up?
I mean, obviously, if there are tax reasons to do it, so for high net worth individuals where they're concerned about going ahead and maximizing kind of the high exemptions that are in place currently, that may have concerns about those exemption amounts falling, sometimes they'll do that. I know, there is what's called the Tennessee Investment Services Trust, or you'll hear TIST. So for people that are really concerned about creditors, they may put that in place if they feel like there's a high probability that they would be sued. Sometimes we'll do gift trust. So we have grandparents that want to go ahead and start gifting assets to grandkids, but they want to make sure that there's still some level of control. They're going to be making significant gifts that they don't want held in like a UTMA account that's going to pay out to the grandchild at 21. And so those will be irrevocable trusts that are in place to hold those gifts and provided for how it's spent kind of moving forward. Those are obviously much less flexible in terms of when the client changes their mind. There is some flexibility under the law, but it's generally going to involve kind of third parties having to consent to this process. Because once you've created this trust, there are other people that have rights to this property at this point in time. Okay, with a revocable trust, you've provided a plan as to where things go, maybe after your death or what gifts are to be made, but you can revoke it, you can amend it at any point in time. So nobody actually has a vested interest in that trust at that point in time. With an irrevocable trust, you have people whose interests have already vested. Okay. And so you can't take that interest away from somebody without there being a process involved.
Yeah, okay, that's helpful to know. Thank you. Because I have come across people who have set up irrevocable trusts and funded it, and it's for the benefit of their family. And whether they're doing it for asset protection or like you mentioned, the tax or the estate tax. From my conversations, I feel like they feel like, hey, it's still their money, they can access it and use it for whatever they want. It's like, well, not really. Once you put it in the trust, like now it's like the trust is technically managing it according to however you set up the trust. So it is helpful to hear like, hey, if you didn't understand that, if you got maybe, let's say you got sold a complicated trust you didn't need, and what would you say there? Let's say somebody did get sold a complicated trust they didn't need. How would they go about fixing that?
I mean, it's probably, I can't give you like a set solution. So it's going to be reading through that long trust document every time, seeing, do we have a way out of this? What is it? Figuring out who the beneficiaries are, what's allowed for under the law in terms of, can we modify this? Can we potentially go to the court or to the beneficiaries and ask for it to be terminated? Can we enter into some sort of agreement? So it's really going to depend upon the document, what it says. And again, do we have minor beneficiaries? Are they all adults? It's going to be, a case by case situation and answer.
Yeah. Okay. Well, and I've done a little bit of tax research. I'm enrolled agent for the IRS. I'm a tax nerd, and the taxation of a trust. Some people will see online like, oh man, the trust tax rates are so small. Like, my money's going to erode by paying the tax on a trust, and I just wanted to highlight like, hey, well, trusts are not double taxed entities, right? So any income that distributes out of the trust, and a lot of the trusts that especially you've set up, like that's the intended purpose. Unless control is more important, then the income is distributed, right? So then the beneficiary is paying the tax at their rate, which they have much
If
higher
we
tax.
have a beneficiary that we trust to manage kind of the interest and dividends and the income the trust generates, we generally try to flow that out to the beneficiary. But we also kind of always say, let's not let the tax tail wag the dog. So if we have a beneficiary that
Yeah.
is not going to manage this wisely or is going to use it in a way that's maybe harmful for themselves or others, we'll just maybe pay out at a higher tax rate. Okay, so it's again figuring out the goals and kind of who the players are.
Yeah, then that
But
should
there
leave
is
the
a way to
decision
flow it
one.
out and have the beneficiary pay the tax at a lower rate.
Yep, yep. I just wanted to distinguish between the estate tax that you were talking about, where the exemption, um, and like just year-to-year federal income tax.
Yeah.
Which the exemption is going to change. Right now, I don't have the number off the top of my head, but I mean, it's like 12, it was 11 million for, uh,
13.61 this year, so it's 10 million
okay,
adjusted for inflation.
that's what it was. Yeah,
And if they do not act before then, it is set to drop in 2026 to 5 million, and that's also scheduled to be adjusted for inflation. So
right.
we'll see what happens.
Yeah, to be determined. All right, I'm curious. So let's say um, your spouse passes away. What's the first thing you need to do from an estate planning perspective?
I mean, we kind of always tell clients when we've had a spouse pass away, obviously take care of yourself, do what you need to do, get through the funeral. There's generally nothing that needs to be done immediately, but then you probably do need to sit down and talk to someone. And it may be as simple as, claiming accounts and life insurance, filling out beneficiary claim forms, moving joint accounts over into your individual name. There may be no probate that needs to occur, but let's sit down and sort through some of that. In addition, I think one of the things that gets missed is sometimes people will sit down with another professional. That professional will say, well, you don't really need to do anything because everything was joint. You were named as a beneficiary on everything. There's nothing left to be done. And there still needs to be some analysis if we have kind of a higher net worth couple. Well, do we want to file an estate tax return at that death to preserve the unused exemption of the deceased spouse? Okay, so now as a married couple, as long as you file that return for your deceased spouse, you can preserve their exemption. So in effect, you can have a $27 million plus exemption that you can leave your kids. Once we drop to the 5 million, it would be, a $10 million plus, depending upon kind of what the adjustment for inflation is. So that can be really important for some couples. And because we don't know what's going to happen with it, it's kind of important. We say if the gross estate is in excess of 3 or 3.5 million, let's go ahead and file it. And then kind of the surviving spouse knows they have that larger exemption kind of in their back pocket. Sometimes I'll update the survivor's estate planning documents just to make it easier for their kids. So if dad's named as first agent for finances, well, if I go ahead and remove dad's name and we're appointing son to serve for mom, it makes it easier for son if we go ahead and step him up into that first position. When he goes to the bank, he doesn't have to explain why dad's not there and potentially present a copy of the death certificate and all of that. So again, first step is take care of yourself, get through the funeral, do what you need to do, and kind of when you feel like you're ready, let's sit down and meet. And there are certain tax elections that, depending upon what documents we have in place, may need to be made within like kind of 9 months. And it's good to have a conversation during that time frame. For somebody kind of on your end that you feel like might disclaim assets, so if the survivor just truly doesn't need these assets, we're thinking about disclaiming them and letting them pass to the kids. It's just important not to go ahead and claim things and to have a conversation with the attorney first and make decisions about what you're going to do. Because once you've claimed something, you can no longer disclaim it.
Yeah, thank you. That is helpful. I know if I died, that would be my instruction to Katie. Is her first phone call would be to call you. Katie's my wife. For listeners who don't know that, but so let's talk a little bit about common mistakes that you've seen with estate plans and how to avoid them. I think this would be insightful.
I'm seeing this one less often, but I think when I first started practicing, there was a lot of we're appointing the oldest son to handle this, and we're going in age order, kind of regardless of skill set. And that's not always helpful because sometimes maybe the oldest child is not the one that's best suited to kind of handle an estate administration. Maybe they don't communicate well with siblings and their siblings don't trust them, and it just kind of creates a mess. Or maybe they're the one that's borrowed money from mom frequently throughout mom's lifetime, and now that mom's incapacitated, they continue borrowing money from mom, and now they have access as agent under her power of attorney. So that's why kind of meeting with somebody where you have these conversations about family members and kids and who's still on the dole and who's not, and who are mom and dad still helping out. Those can be really important. I think the other one, we have a lot of people that even come in and meet with us, and it's kind of like, I want a 2-page will. You know, what I need in place, I just need something very simple. I want it to be very short. And I met with some people recently that they had a will, and it didn't address grandkids at all. And it was actually things were worded in a way where their grandkids would be disinherited if one of the kids predeceased them. It certainly didn't include provisions about how things were to be handled on behalf of minors. And I see a lot of wills where that occurs. So we may have language in there indicating it passes to grandkids, but there's nothing in there saying, here's how it can be held for them. And that can make things much more complicated after your death. We kind of have to, if we have minors involved, we have to involve the court much more than if we're just including provisions in your will that says, you know, it can go to a UTMA account, or it can go to a trust for them, or kind of here's how it can be held, and here's who makes that determination, and here's who's in control of it. So, you know, having a will that maybe addresses more and is maybe a little longer than 2 or 3 pages can actually make things much simpler for whoever's handling the administration of your estate.
Yeah,
You're just appointing the wrong people and making sure that your will actually covers everything you need it to.
Yeah, that's huge. That's really important. And, you know, that was the whole point of it. So let's make sure, yeah, that it's done right. The only things I would add would be the from that presentation with the county clerk. He talked a little bit about the online wills, and he said, you know, like 1 in 3. You know, and this is his estimation, not an exact data, but he had estimated, you know, 1 in 3 online wills has some hiccup before it can be processed, whether it was not executed correctly or didn't have, you know, the 2 witnesses that Tennessee requires, or the self-proving affidavit, or they merged that into one thing, and so I don't know if you have thoughts or opinion on whether online wills are a net positive or net negative, but then the second thing. Nope, I don't even remember. Maybe it will come to me.
I mean, what I'll say about online wills, if you have the most vanilla situation ever, it might work for you. But that means, you know, this is a first marriage. We have kids together. We're leaving things to them. We don't have concerns about any family members. We don't have concerns about how the kids are going to handle things. And for most people, that's just not the case. When we really sit down and talk to them, it's, I have concerns about this child, or I have concerns that this family member might try to involve themselves, and I wouldn't trust them to handle things. Or, you know, husband really wants to appoint this guardian, but wife really wants to appoint this one, and we need to sort through some of that. And so the online process doesn't really assist in those situations. And when I've seen online wills where people tried to make any sort of change to the form or do anything kind of special with regard to their estate plan, they can screw it up pretty badly. Okay. And then sometimes we have to involve the court and say, what does this mean? You know, what do you want us to do with this? Because it's drafted incorrectly, or it doesn't make sense, or it's unclear what's supposed to occur here. So I don't know if that answers kind of where you were.
That does. And that reminded me of the second thing. And these are not my experience. These are things that I'm pulling from
and we see a lot of documents where, like, we have powers of attorney, great, husband's appointed wife, wife's appointed husband, but we don't have successors. And so for one of them, that's not going to work out. Or if they're in a mutual accident, for both of them, we have a problem. And so that's sometimes with the online documents, that's one of the kind of situations we see arise.
Yeah. And the second thing I was going to say, maybe a common mistake, would be working with an attorney who is not a specialized estate planning probate attorney, and that's where, from the county clerk, he had said that he can tell a difference of when somebody's being represented by a dedicated estate planning attorney and somebody that's maybe doing it on the side as a favor to help a friend. So
and what I'll tell you is, if a client comes us and says, we're getting divorced, can you represent one of us? Our answer is going to be absolutely not. Here's some amazing divorce attorneys that we work with. Call one of them. If it's my grandson got a DUI, can you help him? No, but I can give you the name of somebody that can. And so we make sure that kind of we specialize in what we do, and we don't handle kind of all of these different things. And I've seen some really bad wills that were prepared by attorneys that just don't they think, oh, it's a simple will. How hard can it be? And they screw it up. So I mean, I had got a will at some point very early in my practice where it had said this bank account goes to this person, this piece of property goes to this person, but there was no residuary clause. So there was just no clause saying here's where everything else goes. And maybe all that woman owned at that point in time was that bank account and that piece of property. But by the time she passed away, she had 4 or 5 different bank accounts. She had an investment account. There were 2 other pieces of property. And so we had this administration where we had a will as to part of it, and then she was intestate as to the rest of it, which is obviously not a great result and probably not what she intended to do.
Yeah. And just for those who don't know what intestate is, can you explain that?
It's when you pass away without a will. So if you don't have a will where you've made provisions for your family, the state of Tennessee has written one for you. So there is kind of a statute that outlines where your assets would pass. And that can also yield some pretty bad results. So I got a phone call at some point where it was a man that wanted his aunt's house to pass to her caregiver. So it was a house that wasn't worth a whole lot. And the caregiver had lived there with her for 4 or 5 years, and kind of the family that was still in contact with the aunt, their intention was it really should go to her caregiver. And when I started talking to them, the aunt didn't have a will. She had been like one of 12. Each of the 12 kids had multiple kids. This woman was in her 90s, so half of her siblings were deceased. There were several still living. And so I kind of started walking him through the intestate succession. And just of the beneficiaries he knew, because he was not in contact with all of these people, and he didn't know if some of them were alive, how many kids certain people had. We had like 56 beneficiaries. And so I was like, getting 56 people, like tracking 56 people down and getting 56 people to sign off on, giving their interest in this property to this caregiver is going to be really expensive. And it's probably going to be nearly impossible. And so again, just having a document in place where its aunt leaves her house to this caregiver would have been much simpler for everyone involved.
Yeah. Wow. Um, yeah, that's so even for um, younger individuals or young families, like even if you're just at the beginning of your wealth journey, like I still think getting these documents in place are important because to your point, if you don't have them, well, the state that you live has a plan for you. And when you
Right.
have children, like they will do their process to find a guardian, and but it may not be who you wanted to be the guardian of your children, right? So I
And
think
it
it's super
could,
important.
could cause fighting amongst family members. So, there are a lot of families that if you've clearly chosen a guardian, even if people aren't happy with who you've selected, maybe they're still going to respect your wishes.
Right.
If you left a void there, inevitably somebody from each side of the family feels like they need to step in and petition. And then once they've done that, they're invested and they may not be able to compromise or reach an agreement. And so there may be, you know, a long period of time where they're fighting over who's going to wind up with the kids or who's going to wind up with control of whatever money you've left to the kids. And so it's really better to just go ahead and appoint who you would prefer to do it. And even with powers of attorney, we tell people, if you become incapacitated and you don't have powers of attorney in place, it's kind of whoever in the family goes down and says, appoint me as his or her conservator. And they're asking the court to find you incompetent and to appoint them to handle certain things. There is kind of a lineup as to who has priority there, but there are categories where there may be multiple people. So if it's a parent and there are 4 or 5 kids, well, we may have 2 or 3 kids that think they should be the ones doing it, and they may argue over who it's supposed to be. And so just having documents in place where you've clearly outlined your wishes can reduce family conflict. And again, then you're exercising kind of your choice as to who you want to serve.
Yeah. Yeah, and so this is now my opinion and not fact, but this is where I think maybe an online will provider could add value because it's estimated half Americans don't have wills, and if like you're just at the beginning of your wealth journey, there's not any complexity, but like okay, and because Lauren, you can't serve everybody,
Yeah.
unfortunately, like you're probably better off to at least have something in place than nothing. Exactly for the reasons that you said. You're not intestate. You could avoid some family contention. Um, you have somebody in place in case, to make decisions. I know there's that famous case out there, and I can't remember, you probably know exactly what I'm talking about, where the there was disagreement about it was I think boyfriend and girlfriend, and there was disagreement about whether the boy or maybe it was even a husband and wife, but of whether the parents or the spouse or the partner would make the healthcare decisions. And do you know what I'm talking about?
I think
Somebody
you're talking about
stayed
the
on.
Terry Schiavo case in Florida, and parents
Yeah,
wanted to kind of leave her on life support, and husband said, "I think it's time to withdraw life support," and so they were in court. What I'm going to say is, online, obviously, it's better to go and sit down with somebody that can counsel you over doing kind of online documents. If that's the only option available, sure, it's better to have that in place. But, at least at our practice, we try to make it very affordable and easy for kind of young couples with young kids. We'll oftentimes do things kind of at a discounted rate for them just to try to make sure that they have good documents in place. Because there is that counseling element. I think, the hang up for a lot of young couples with young kids is which family member is going to handle
yeah,
being, serving as guardian or handle the money. And husband may want somebody from, one of his siblings, and wife may want one of her siblings or her parents. And we can help, if they were using an online platform, we may wind up with documents that say two different things.
right.
Whereas sometimes when we sit down and meet with people, we can help them reach an agreement and make sure both sides are included, or figure out kind of what each of the spouses is thinking in terms of what their priority is and kind of why they're wanting to name who they're wanting to name, and kind of broker an agreement where everybody's on the same page. Because I do think
Yeah.
that's one of the hangups for younger clients is who are we going to appoint? Who is the best person?
Yep. And I agree and I concur. I think that is best, right? If you think good, better, best, I think sitting down in person with an attorney, getting the counsel, that would be the best. Um, and because we're going to have people listen to this who don't live in Tennessee, I'm curious, how would you guide them? Like, if they wanted to meet in person with an attorney instead of just do it online, how would you recommend them going about finding somebody that, they're at least directionally in the right, going the right, um, they're directionally right when they're searching for an attorney. How would you, what resources would you tell them to go
I
search for
mean,
an
when
attorney?
occasionally we need an out of state attorney to handle like an ancillary administration, something like that. And we kind of start out with, we're going to try to find somebody that is situated kind of like we are, so that it's, a small to mid-sized firm that focuses on primarily estate planning. That's more of a boutique firm. Okay. You know, we kind of look at professional organizations. We're part of the Knoxville Estate Planning Council. There are estate planning councils in other areas. So is this person a member of kind of the estate planning council in whatever city we're looking in? Reading reviews. You could potentially call the bar in whatever city this person is in and say, can you point to someone who that can handle kind of an estate planning matter? So that's kind of at least how I might start out looking for someone. You can talk to your financial advisor. They're a good resource. They know if what attorneys they've worked with in the past, who they feel like does a good job. They probably have some idea in working with other professionals. Sometimes CPAs are a good resource. We work with various CPAs in town fairly closely, so they probably have some kind of instinct about who they would go to. So that's kind of where I would start if I were looking in a different city.
Okay. Yeah,
And again, I
that's
know
really
for
helpful.
you, you've reached out and said, can you find me somebody in this state that would be good at this? And so I'm always willing to get, find that referral and say, this is who I would go to for someone. So just
Yeah,
if you know
you're
an attorney
very
that practices
kind
in
and
another area, they may know an estate planning attorney that they've worked with. Okay.
you were very kind and generous. I wasn't going to open you up to internet strangers emailing you out of state recommendations. For people who are in Tennessee and who've enjoyed this conversation, want to meet with you, what would be the best way for them to get a hold of you?
Call our office. So just call. I know that Michelle and Allie are typically who schedule kind of new estate planning appointments. And so they'll be happy to get people scheduled to meet with us.
If something here resonated with you, if you've recently moved to Tennessee and you need to review or update your estate plan, then there is the email and phone number. We'll make sure to have that in the show notes as well. And then we'll point to some of those that the estate planning council where you may be able to find someone in your own state if you're outside of Tennessee. Um, Awesome. And then just before we wrap it up, is there any last thing that well, and let me say this, one thing, another reason that I like working with Lauren Brown and her firm is that they charge a flat fee on the estate planning preparation. So after they meet with you, they do they kind of say, here are some of your options, and here's what each of these options will cost. And a lot of time the option is, maybe something more like simple without a trust that's still accomplishing what you want. Maybe something with a trust and what the different prices of that would be. Um, and you can choose, and then you're not worried about getting billed on an hourly, or if you have a question or a phone call, like what you're paying the flat fee. I like that. I know on the estate administration side, it's an hourly rate, right? Do you want to talk a little bit more about how you've structured your price and why you've done it that way?
Well, and all attorneys do things differently. So, kind of even in town here, there are other estate planning attorneys that work on a flat fee basis with the estate planning like we do, and then there are attorneys that do a combo. So it's a flat fee for this portion of it, but these other things we're going to bill hourly for. For us, I think we feel comfortable that we know in general for the average client how much time we're going to spend both meeting with the client, explaining documents, getting things signed, working with their financial advisors, drafting documents, that we feel very comfortable with our flat fees, and we don't feel like we need a bill hourly in addition with the estate planning. And part of the reason we do that is it does make people more comfortable. They know kind of what they're in for, and we want all of our clients to really understand their documents and understand how they work. And so we don't want people to be scared to ask questions. So if you feel like you're going to get billed for every question that you have, there are going to be things that you're going to choose not to ask. Okay. With estate administration or probate matters, it's a lot harder to tell kind of what the time is going to be. And what I'll tell you is, there was one meeting that I was in at some point that I was meeting with siblings, and all of them were just, we all get along so amazingly. This is going to go so smoothly. There are going to be no disagreements here. We have wonderful relationships. I'd stepped out to copy some things, and the wife of one of the siblings stepped out and said, they all hate each other. This is not going to go well. And I was like, thanks. But, that's part of the reason that we do kind of the hourly rate with the estate administration, because it's just really hard to know. Things pop up, assets we didn't know about pop up, creditors we didn't know about pop up. And we kind of have to, it's really hard at the outset to be able to predict everything that's going to occur. So that's kind of why we handle things slightly differently. But even with the estate administration, you have some ability to control what our end fee is going to be. And that can cut down on some beneficiary disagreements. So, if we have two beneficiaries that are fighting over a chair at mom's house, well, if you're emailing, if you send me 45 emails about this chair at mom's house, it probably costs more than what it costs to go buy another chair. And we can kind of point that out sometimes, and that will help them get along and just decide who's going to take the chair.
Before we wrap it up, and on that point, because we do have a lot of people that move to Tennessee for retirement, a lot of times they're leaving children behind in other states. And so what is the advantage of working with you or an estate planning attorney in this, for those children that would have to travel from out of state in order to help with the administration?
It does give your children a known resource here. So Tennessee, your child's still allowed to serve as trustee or personal representative. There's no restriction. They don't have to be kind of a resident of the state of Tennessee. But it may be difficult for that child to go back and forth, getting your house cleaned out or meeting with people to do an estate sale, meeting with realtors at your home. And so our office can take some of that off of them and assist them in that process. And we kind of know, realtors that we've worked with in the past, or auction companies, estate sale companies that we've worked with in the past. So they have that resource. We're also here to kind of go to court for them and attend hearings for them. They don't have to travel back to kind of deal with that.
Yeah. So can ultimately, just help with the ease of administration, and maybe they don't have to make as many trips.
Most people's
back
kids,
and
unless
forth.
they're also retired, don't have the ability to relocate back home or travel back and forth 5 or 6 times to attend to estate matters. And so having us as a resource here allows them to come back, handle deal with the funeral. Sometimes they meet with us during that time frame. Sometimes they meet with us via Zoom or over the phone after the fact. But it lets them kind of go back to their daily lives, and they're still handling the administration, but they have a resource here in town.
Yeah. So if I can imagine doing that myself, I would, you would be on my speed dial if I ever needed to do that personally. So, awesome. Is there any last thing that you want to say? Any last tip or piece of advice or educational wisdom that you want to impart?
I mean, I think just as a general rule, get estate planning documents in place. Again, it makes things much simpler, much easier for your family. It's a comfort to you to just go ahead and do it, even though maybe you're dreading having these conversations. It's probably going to be much less painless, or yeah, much less painful than you think it's going to be. And it certainly can save a lot of heartache on the back end.
Awesome. Well, Lauren, thanks for joining us, and we'll make sure to include everything in the show notes. Thanks, guys, for listening, and have a good day. As we wrap up, remember that your financial match point is within reach. Connect with me at retiredtoteleco.com for personalized guidance and additional resources. If you found value today, don't forget to subscribe and leave a review on your favorite podcast platform. Thanks for listening. This podcast is for informational purposes only and does not provide financial, tax, or legal advice. Each individual should consult with their dedicated financial planner, tax preparer, estate attorney, etc. before making any financial decisions.